Hi, everyone. My name is Ankita Shanker. I'm a PhD candidate at the universities of Basel and Antwerp, and I'm presenting on that topic. It's based on a paper that is being written by Dr. Angus Nurse, a UK-based criminologist, and me, a various countries-based nobody. And here we go. So this paper is essentially a critique on alternative regimes that seek to protect animal rights through a primary focus on something other than animal rights. It considers the implications of protecting animal interests indirectly through instrumental means, such as human rights or environmental protections, rather than direct means in the form of actual animal rights protection. So while the former approach may have strategic advantages in the short run, given how humans are rather selfish and mostly care about things that concern them more directly, it lays a shaky foundation for the protection of animals and their interest in the long run, which is why our paper advocates for the protection of animal rights through animal rights law, and explains why this is necessary by demonstrating the negative impacts protecting animals through other types of law has on law and society. So the notion of animal rights is an emerging trend in various spaces, judicial, political, societal discourse, but one of the key prerequisites to recognizing the fundamental rights, hereafter just rights, of anyone is their de-objectification, which is the elevation of their status from legal objects who have no recognized interests to legal subjects who do have recognized interests. So long as an entity is objectified, it doesn't really make sense to speak of their fundamental rights, since they have no recognized interests in the first place, so there is nothing for the rights to protect, of course, on the rights theory on the interest theory of rights. Better? Oh, yeah, that sounds better to me as well. So here we recall the useful distinction between having rights and having rights recognized and protected. In simple terms, it's entirely possible for an entity to have fundamental rights and be a person whilst remaining legally objectified, such that their status is neither recognized nor protected. And non-human animals, hereafter just animals, might be a prime example of such a group, because any rights that they actually have or any personhood they have is neither legally recognized nor protected in any meaningful way in any legal system of which I'm aware. So animals are currently treated by law and society as commodities with primarily, although not exclusively, instrumental value to some other rights holders, such as humans or nature. And so most protections that are afforded to animals are done so primarily in furtherance of the interests that they further, like societal, social morality, human rights protection, environmental protection, and so on. Animal protections, even if they are termed rights, as they sometimes are just an application of the extension of the rights of humans, or more commonly, the rights of nature. And what this means is that animal interests are not always protected or even recognized in their own regard, but protected as stemming for some other reason, or even worse, as a means to some other ends. And this has two identifiable impacts from a legal perspective. One is that animals are not seen as inherently valuable, and two is that animal protections are not seen as inherently justified, which in turn, as David Bilchitz has noted, means that there can be no fundamental protection of animal interests. Or in other words, legal protection does not always entail protection of animal rights qua animal rights, which is needed for the protection to be meaningful and to be effective. And the effects of this legal paradigm do not actually end at the legal status of animals, because this position also affects how persons and societies of which they form part see animal protections. And generally, we see them as part of protecting the interest of humans or the interest of nature. So, I mean, where of course they are seen as, where they're protected as part of these interests. So animal protections are then seen as valuable only so insofar as they further these other interests, as opposed to valuable as protecting the rights of animals who have inherent worth and value that deserve protection regardless of whether or not they serve these other interests, regardless of whether or not they're useful to us or necessary for ecosystems. And this does nothing to truly de-objectify animals in the minds of people, because even though most people would agree that animals are not objects, they continue to treat them as such whenever it serves them to do so. So there is no country, for instance, no legal system under which it's illegal to breed animals and to treat them in horrendous ways and then to kill them and eat them. Actually, maybe Bhutan. I think you can't kill them and never mind. You can still eat them there, though. For individuals and society to truly resolve the inconsistency between the alleged stance that they take and the actions in which they participate is for us to acknowledge that animals are more than objects on a psychological and societal level, and then to act in a way that is consistent with that. And in the paper, Dr. Nurse and I examined the implications of this perception of animals and their impact on the legal protections afforded to them and on the minds of individuals and societies. So we argue that change in the legal and societal status of animals can be brought about only through legal, psychological, and sociological acknowledgement that animals have inherent value and deserve protection on that basis. Animal protections derived in such a way would not need to place reliance on other justifications and would thus not be subject to subjugation to those other rights should competition or conflict arise. In other words, animal protections derived in this way would be animal rights proper. Then we move on to definitions and distinctions. Animal law, subset of law that deals with the status and treatment of animals under law. Not very complicated concept, I guess. It's commonly believed that it exists to protect animals, but this is only half the truth because it equally exists, building on Gary Francioni's observations, to exempt animals from protection wherever it is in human interest to do so. This is why it is justifiably argued that most, if not all, existing animal law is, in fact, animal welfare law as opposed to animal rights law. So animal law made up of welfare and rights. Animal rights, I'm using to refer to fundamental animal rights, and in the most simple of terms, it's a series of safeguards afforded to animals to protect their definitionally inherent interests against unjustifiable infringements. So this paradigm views animals as having inherent value, which means that a fair balancing exercise must be carried out wherever there is competition or conflict between an animal right and any other right, including those of humans. It's never done. Human rights law is a subset of law that deals with these notions in the context of humans. We don't have human welfare law, so we're just going to focus on human rights law, not human law. Made up of welfare and rights, it's not a thing. This branch of law achieves all the things that welfare law cannot and encompasses factors that are needed for the protection of rights which welfare law does not. And then environmental law deals with these notions, but with regards to the environment, ultimately it exists to further the interests of humans, present and future, and occasionally, though often purportedly, the interests of other inhabitants of the earth. So when animal rights derive from environmental law, they are 2 stages removed from any notion of inherent animal value. We can thus broadly say that animals, humans, and nature are 3 types of rights holders, or considered to be. So most of my PhD thesis is making the distinction between having rights and then having them recognized. So when I say there are 3 types of rights holders, I mean that they actually have these rights, whether or not they're recognized. The interests of each of whom are regulated by their own legal regime. And what we argue in our paper is that it's really problematic if a group of rights holders are protected in an incidental way within the regime that aims to directly protect another set of rights holders. Okay. Competitions and conflicts. So all the regimes have their own goals. Animals interact with humans who interact with nature, who then interact with humans, so everyone interacts with everyone. And then it's very natural that all their interests might compete or even conflict because of their interactions. So humans and animals, very clear competition because they're sentient beings, they have similar interests in security of the person, including things like life, liberty, shelter, and food. And then they share a planet which has limited resources. So this means that they'll obviously find themselves in competition with each other to meet their needs. The conflict aspect is also clear when we consider, for instance, the systemic dependence of humans on the exploitation of animals as resources to meet their own needs. So as the ambit of the recognized rights of one holder grows, that of the other will naturally diminish, insofar as the former involves using the latter as a means to their end. So this is building on Arthur Ripstein's work in the context of his sovereignty principle. So when animal welfare provisions kicked in, human rights that involved abusing animals gratuitously were curtailed. And if animal rights kicks in, human rights that involve using and exploiting animals will meet a similar fate. Then we have the rights of nature angle. So humans have conquered nature. We're seen as distinct. Conflict is, or competition is easily evident. We compete with nature for space, primarily. And the interests come into conflict where humans and nature have opposing interests, so pretty much everything we do as humans. Animals, in contrast, are seen as part of nature, which is largely understandable due to the fact that the former live in synchronicity with nature and the two are heavily mutually interdependent. For animals who live in and rarely modify nature, competition with nature is much rarer, though there are some exceptions in the case of animal species who, like humans, modify nature, though typically unintentionally. But then we have those birds, firehawk raptors. So they literally burn down vegetation like forests. Either we don't know why or I can't remember why, but it's pretty interesting. They have like these things on fire between their okay. Animal-nature conflicts are not at all difficult to envision because nature benefits from having sustainable positive ecosystems, for instance. And certain animal species in certain numbers are beneficial and desirable, whereas other species or even desirable species in other numbers are not desirable. And this is one of the reasons that pro-animal rights and pro-rights of nature scholars often clash. So as authors such as Mark Sagoff have noted, the latter would, in principle, be in favor of violating the rights of individual animals to achieve the nature-favoring equilibrium, and the former would be, in principle, amenable to sacrificing the interests of nature to safeguard those of animals. In many contexts, the latter of these can be argued to be a short-sighted approach because animals are heavily dependent on healthy ecosystems, but even with this line of reasoning, right? It makes no sense from a rights perspective to speak of culling or forcibly breeding humans. We're also dependent on healthy ecosystems, and therefore it makes no sense to speak of doing these things to animals. So humans are the most disruptive species the planet has ever faced. Our dominion over nature and over animals has remained largely unchecked because our interests and the rights that are generated by them are given primacy. And how competitions and conflicts are resolved is a function of the relative legal significance that is assigned to the rights of these various rights holders. So the hierarchy typically goes humans, then nature, then animals. And then this has various legal implications on, and some of the ones I'll be focusing on today are those on legal philosophy, theory, case law, and psychosocial status of animals. So incidental animal protection for philosophical and theoretical scholarship, the three I'm focusing on, here we go. Yeah, those, I'll leave out D. It ignores animals' inherent value and interests. It's based on a shaky foundation that can be undone to the detriment of animals with relative ease, and it precludes any question of fair balancing in competition and conflict cases. So, instrumentalist branch of legal philosophy and theory doesn't regard animals as ends in themselves, as noted by me and Eva Burnett-Kempers. Philosophical and theoretical justifications for animal protections that rely on such reasoning ignore the intrinsic value of animal interests as deserving protection in their own right. So all that remains is the instrumental value of animals. To other rights holders, animal protection is justified as the protection of human interests, such as public morals, or environmental interests, such as preventing imbalances in ecosystems. And animals are seen as part of these human morality, environment, etc. And legally protected only insofar as they contribute to one or more of these higher goals. So animal interests that don't contribute to these goals are deemed irrelevant, and this is especially problematic when all contexts in which animal interests matter are instrumentalist. Second implication is that instrumental arguments for protection provide no rights per se, so they expose individual animals to sacrifice for the collective and animals to risk of subjugation to humans and the environment. So, as Sagoff has noted, animals are treated as no more than an expendable and irrelevant piece of a collective, and animal protection is a secondary consideration because animal interests are necessarily sidelined in that they're seen as automatically stemming from some other goal. So if competition arises, it's obviously going to be resolved in favor of the other goal. and arbitrarily termed the greater good. And even basic entitlements can be overridden if it's in furtherance of these primary interests. Third point, where a right is merely an incidental effect of the realization of some other right, it is not fundamental, because in such cases, building on the work of Ann Peters, there can be no attempt at fair balancing, since the primary right will automatically be prioritized over the incidental one. I'm going to skip through that. And then case law. Number of cases from across the world that seek to protect animal interests as an extension of environmental interests or human interests. Those are some of these cases. There's a paper that Eva and I wrote that discusses these and a lot more. It's really, really good, so yeah. So in essence, these cases have strategic advantages that, for instance, they preclude allegations of judicial activism because they fall within existing protection regimes, but they set a very poor judicial precedence for the protection of animal rights as animal rights. Then we move on to the psychosocial implications. So first, by civil societies, animals are viewed instrumentally that furthers their objectification. For instance, therapy animals, service animals are valued only for their value to humans, and their own interests naturally count for less than those of the humans that they are supposed to be helping. Criminologists emphasize links between animal abuse and other offending, which overshadows the inherent problems with animal abuse itself. So theorists argue for the reduction of animal cruelty, prevention of abuse, provision of equal treatments by creating, so that it creates a society that is increasingly cruelty-free, but for humans. Animal abuse and cruelty are considered indicators of other violent crimes against humans. Animal abuse is seen as a stepping stone to larger problems. Animal abuse itself is also seen as falling outside of mainstream offending. Policymakers, animal protection and crime is treated as a fringe area of policy. It's largely defined as purely a human or environmental issue, both internationally and at the state level. For instance, animal protection is left in the hands of environmental or agricultural departments and falls outside mainstream policing priorities. Also a problem if animals' interests are being looked after by organizations that are aimed at using animals as food. Animal interests are sought to be protected insofar as they align with human or environmental interests. So examples would be ecological justice and argument and the progression thesis, which I don't have time to go into. By lawmakers, animals are given value commensurate with human interests, and actual crimes are constructed around human valuations. So wildlife receives less protection than companion animals. Animal abuse is somewhat legalized rather than criminalized, where continued exploitation is permitted and regulated because it furthers some human interest, like under animal welfare laws. Animal welfare protection has been recognized as being for public benefit and instrumental public good by courts all over the world. Animal welfare benefits those with an interest in animals as property, so producers, as consumers in the context of their health, and even as consumers from the perspective of so ethical consumerism, for instance, it helps give them a psychological sort of well-being from buying ethically sourced animal welfare compliant goods. Instead, what we want is treating animals in a way that's appropriate to the animal in question, not in ways that further their use by humans. Actions towards animals should be grounded in understanding species-specific modes of life and the needs associated with it. Actually, that was it. So in conclusion, the only way to offer animals any meaningful protection for their interests relies on animal rights law for animal-focused protection. But all said and done, I do want to stress that the argument being made is not that lawmakers and society should not refer to the interdependence of non-animal interest and animal interest. Instead, what we're advocating for is that law and society should ground animal rights in animal interests and animal interests alone. So if non-human rights are to be referred to, they should be treated as additional reasons for respecting as opposed to grounding the existence of animal rights qua animal rights. Okay, I'm done.